Welcome to Daily Drive for Thursday, August 6, 2026. I'm Callan Walker in Las Vegas. Today on the show, Japan's automakers are mostly back online after last month's earthquake, with one big exception. Ford's affordable electric pickup finally has a name, and an international dealer group wants Chinese vehicles out of the U.S. market. Plus, ACLU of Northern California attorney Nicholas Hidalgo talks about a court case in California that could change how license plate reader data is collected and what's at stake for the repo industry.
I don't think companies that use this technology need to be worried if they're already complying with SB 34, as they should be.
Let's run through all the news you need to know to keep up in the auto industry. Most of Japan's auto industry is back online following last month's deadly 7.1 magnitude earthquake in Kyushu. Toyota, Nissan, Mitsubishi, and Daihatsu have all resumed production. Honda remains the exception, still down through at least August 19th, held up by a damaged supplier, Astemo, which makes damper components, hasn't been able to come back online. Honda's CFO says the company still doesn't have a clear restart timeline. Industry-wide, the disruption is on track to erase nearly 20,000 vehicles of output. American Honda says U.S. inventory is not affected. Ford's $30,000 electric pickup has a name, the Fathom. The automaker says the midsize EV truck will start at just under $30,000, a price Ford executives set deliberately to take on the industry's affordability problem. Ford Model E General Manager Kay Hart says the name was meant to give the truck a soul, designed for a customer who doesn't look like a traditional truck buyer. Fathom will be built in Louisville, Kentucky. Pre-orders open in early 2027 in the U.S. and Canada, with deliveries later that year. A major international dealer group is calling for a ban on Chinese brands in the U.S. market. The American International Automobile Dealers Association says Chinese automakers are aiming for total market domination, and that it amounts to unfair competition that would ultimately hurt the brands its members already sell. The catch? Many of those same brands have deep ties to China themselves. Our own Molly Boygon has the story at Automotive News. She spoke with executive producer Jake Neer about it.
Molly Boygon, welcome back to Daily Drive.
Thanks for having me, Jake.
Always great to have you on the show. This is a really interesting story. First of all, the legislation, the Connected Vehicle Security Act, is stalled right now in Congress. If it doesn't move before the midterms, where does that leave dealers who want stronger protections?
It's an interesting question because, as you said, there are companion bills in the House and Senate that are attempting to further limit the sale and manufacture of Chinese vehicles in the United States. And this legislation takes an even stricter perspective than the existing Commerce Department rule, which people may have heard about, that is banning the sale of Chinese vehicle software and hardware in the United States. And this recently impacted Volvo, which got a special dispensation from the Commerce Department, and Polestar, which is actually now banned from selling future model year vehicles in the United States because of this rule. So legislators have tried to tie it to the National Defense Authorization Act, and that bill is being held up in Congress by Senate Democrats who are opposed to the war in Iran and the linking of that legislation to voter ID law. So long story short, if dealers are concerned about the encroachment of Chinese brands into the United States, they should mostly rest easy for now, given that the Commerce Department rule begins to take effect for model year 2027. But if they're concerned about, additional stricter rules, they'll just have to wait until after the midterms.
The other thing I'm wondering about is that the AIADA represents dealers who sell brands like Mercedes, Volvo, Volkswagen. They all have significant Chinese ties. So how does the organization and its chairman, Mike Darrow, square that tension?
This is something that I think the government really is going to have to figure out, honestly. I mean, you see it with the different treatment of Volvo and Polestar, two brands that are closely linked. And the difference has to do with the length of time that the brands have been in the United States, the particulars of the ownership structure. And it's going to end up being kind of confusing how the government is allowing or disallowing certain brands into the United States, because as you say, so many important economic engines in the United States at this point have ties to China. You mentioned Mercedes-Benz. The largest individual shareholder for that automaker is a state-owned Chinese automaker. Volvo is majority owned by Geely. Volkswagen has a licensing agreement with Xiaopeng in some markets, and even not foreign automakers. General Motors builds the Buick Envision in China, though it said that it's going to move production. Ford builds the Lincoln Nautilus in China. The growth of a global economy and a global society has really muddied the waters as to what actually is a Chinese vehicle. So the way that Mike Darrow explained this to me is basically that, if you are a fair player, if you have longstanding ties to the United States, if you've made significant investment in manufacturing here in the United States, then you shouldn't have anything to worry about. And he pointed to remarks by Ohio Senator Bernie Moreno, who's one of the sponsors of the Senate legislation further restricting Chinese brands in the U.S., who said, Mercedes-Benz will never be banned in the United States by the U.S. Senate. So it's partly the letter of the law, and it's also partly vibes and how the government feels about the extent to which automakers are contributing to the U.S. economy.
Molly, you've been very busy this week, and you've been helping us out very much on Daily Drive. We've been hearing your interviews all week about your repo package story, and we're about to hear your conversation with Nicholas Hidalgo of the ACLU of Northern California. Thank you so much for this and everything else you've done for Daily Drive this week, Molly.
Thank you for having me. I hope the listeners are enjoying hearing my voice. I think there's a couple more tidbits coming this week. So thank you so much for having me back on.
And if they haven't gotten enough of your voice, also co-host of the Shift podcast here on Automotive News. So check that out on Sunday. Yes. Thanks again, Molly.
Thanks, Jake.
License plate readers are a critical tool for the repossession industry and potentially a major privacy concern for millions of drivers. A California appellate court has been weighing a case that gets at the heart of that tension. Our own Molly Boygan caught up with ACLU of Northern California senior staff attorney Nicholas Hidalgo just before oral arguments in the case. They recorded the interview just days before the court ruled in the case at the center of their conversation. The decision came down in support of the license plate reader company. The court ruled that the plaintiff, Guillermo Mata, did not have legal standing to sue because he did not suffer an injury. This indicates a split in California. Another case went a different way. Here's a piece of their conversation.
Nick Hidalgo, senior staff attorney at the ACLU of Northern California. Thank you so much for joining me.
Of course, happy to be here.
So, Nick, for those who have not been following, can you tell our audience a little bit about what the plaintiff is seeking in this MATA versus Digital Recognition Network case?
Yeah, absolutely. So MATA is basically a court case about a person whose location information was recorded by a license plate reader company, and the plaintiff alleges that the company was not complying with a California state law, colloquially called SB 34, but it's the state automated license plate reader law. And it imposes certain restrictions on what operators or end users of license plate readers do. So think the technology vendors like Flock or Motorola, or the end users like the defendant in this case, who operated an ALPR system for a private company. But it could also be like law enforcement agencies. And so anyway, the law imposes restrictions on who those sorts of folks can share license plate reader information with, and also requires them to post certain policies to have transparency and explain how the privacy of drivers is being protected and other sorts of things like that. So the plaintiff alleged that the defendant wasn't doing that because they had not published certain required disclosures and policies online. And the Superior Court basically held that the plaintiff, Mata, wasn't able to bring his case in court because he hadn't been able to allege that he had been injured beyond the basic injury of having his information collected in the first place. So we weighed in at the ACLU of Northern California, weighed in in a friend of the court brief, an amicus brief at the appellate court, because we disagree with what the Superior Court held. Our argument is effectively that any collection of a person's information through a license plate reader is sufficient injury without having to allege any other sort of use or misuse of that collection, that the collection alone is a privacy harm. So the case is now, the oral argument has been delayed for a while. Briefing has been completed, but the court asked the parties to be prepared at oral argument to discuss this Bartholomew case, which I'm happy to discuss as well. Oral argument is now scheduled for this week on Wednesday, July 15th at 9 a.m.
Thank you. Thank you. And just before we turn to the Bartholomew case, I wonder if you can just talk a little bit about why the ACLU of Northern California's belief is that privacy is in and of itself injury, even if nothing else happens to people's information or something like that.
Yeah. So the ACLU of Northern California has been involved in fighting against government and private party surveillance for a really long time. We were really happy in the 1970s when the state passed, by ballot initiative, passed a constitutional right to privacy. So unlike the federal constitution, the California state constitution actually has the language guaranteeing a person's right to privacy. And that's in the first article in the first section of the Constitution. And this was passed at a time when there was a lot of concern about government snooping and spying. This is in the Nixon administration. And civil rights advocates around the country, especially in California, were especially concerned with this. So it is a really expansive and strong right to privacy. And it was meant to stop that kind of government surveillance, to stop that snooping, to stop and private parties from gathering lots of information about us and misusing it or even just collecting it in the first place. But the state license plate reader law that's at issue in MATA is built on that state constitutional right to privacy. The language of the legislatures when they were passing the automated license plate reader law make it clear that they were trying to build on the state constitutional right to privacy. And that constitutional right to privacy includes the idea that the collection alone is a sufficient privacy harm in order to establish standing or the ability to get into court to bring your claims. Now, usually you need to prove something else to actually win your case. But in the case of MATA, his case was kicked out on a standing issue, meaning the court didn't even think he should be able to bring his claims because, as I said earlier, he wasn't able to prove or allege any other sort of injury. And that's just not the way the California constitutional right works. And that means that's not the way that SB 34 works. Now, he needed to allege that something else had gone wrong, right? That the license plate reader company, DRN, I believe in this case, had violated some portion of the actual statute. But the collection alone is sufficient under the Constitution and the law, the statutory law, to get him into court in the first place.
And I also understand that this case is in a bit of a different situation on appeal because of the decision in the Bartholomew case, but before this point. And, as you mentioned, the oral argument is moving ahead. The court had been waiting for a supplementary brief on that Bartholomew versus Parking Concepts case. So what happened with that case, and why is it relevant to the MATA versus DRN case?
Sure. So Bartholomew is relevant because it's a California state appellate court case from a different district, which means it has persuasive authority, but it doesn't mean that the MATA court needs to follow, like it's required by law to follow it, but it could still influence their decision. A lot of smart California judges out here, so I won't get into like how the civil procedure works in terms of like when you're supposed to follow what another judge says versus when it's just. Anyway, it's a compelling case, and it's pretty similar. So in this case, a vehicle owner brought claims against a private company, an ALPR operator, under the same law, under SB 34, the state automated license plate reader law. And in that case, the court in Bartholomew disagreed, not directly, but in substance, with what the MATA Superior Court had held, because it said that economic injuries or some other mental or emotional injury wasn't required for the plaintiff to have standing in the case. What the plaintiff was required to show, and had done so successfully in the Bartholomew case, was show that the license plate reader company had collected his information and used it. And that's a lot closer to correct under the state constitutional law and our reading of SB 34, but it's not quite there. Because as I mentioned earlier, our argument in our amicus brief, and we believe the state of the law, is that a plaintiff need only show that their information was collected, not that it was used. That collection alone chills constitutional protected activity. If a person knows that their location is being tracked everywhere they go, they're far less likely to live their lives with full autonomy, right? It might like prevent someone from seeking medical care they need if it's something they'd be embarrassed about or concerned about the legality of. Or they might be more hesitant to participate in First Amendment protected activity like political protests. Or they might be less likely to help their immigrant neighbors, or they may be less likely to send their kids to certain schools. There's a whole lot of situations you can imagine where if just knowing that your information is being collected changes your behavior. It doesn't necessarily matter if someone then later uses that information. That's harmful too, of course, but but under the law, only the collection alone is sufficient to get standing. And so that's why we think Bartholomew, while closer, isn't quite right. So we're hopeful that the MATA appellate court will read our amicus brief and the compelling arguments of the plaintiffs in this case and hold that along the lines of what I've been just saying, that collection is enough injury to raise a privacy concern.
And if the appellate court does rule in the favor of the plaintiff, agree with the arguments by the ACLU of Northern California and other entities, my understanding is that there would be additional restrictions placed on the collection of driver data, of license plate data and sort of related data about location and stuff like that. And, there would have to be additional disclosure about the use and collection of that data. Are you able to say a bit more about basically how practically the outcome of this case could impact the use of license plate reader data, specifically for repossessions or just in general?
So in general, I don't think this case is going to. My position is that anyone using an automated license plate reader system is already required to comply with the text of Senate Bill 34, the automated license plate reader law, which, as I've said, puts limits on how anyone who uses these systems can use, share, retain, and how they have to post notice of this information. What MATA would do if the court were to hold exactly as, if I could write the opinion for the judge, all it would do was reaffirm that collection alone is enough standing to get you into court. But the thing is, if a license plate reader company had collected my location information, but had otherwise completely complied with with SB 34, I wouldn't have a valid claim against them under that statute, right? So I don't think companies that use this technology need to be worried if they're already complying with SB 34 as they should be. If the court were to hold like Bartholomew, that a plaintiff need to show use and collection, or God forbid, like would affirm the Superior Court finding that you need to show some kind of economic injury, then I think that takes the law backwards, because then that requires that a person whose rights have been violated under SB 34 would need to wait until they are somehow actually injured, like somehow financially injured or emotionally injured, or show some kind of extra standing requirement before they're able to stop the unlawful collection of their information. But as I've said, the collection itself is unlawful. Now, the collection may be unlawful under the state constitutional right to privacy, but again, unless that there's a violation of SB 34, this won't bring a lot more. I don't think this will bring a ton more plaintiffs into court under SB 34, especially if companies are already complying with that law. Now, there is no special carve out for a private party. The California constitutional right to privacy applies against both private and public organizations, so law enforcement and private companies. And so, a private company that operates an ALPR system may still need to be cautious about constitutional claims. But again, like the SB 34 is pretty clear. The state AG, AG Bonta, also has a bulletin out that explains how to comply with it. And so, there should be no trouble or misunderstanding about how to comply with that law. So if a company is worried that that the MATA case will, lead to more SB 34 cases, just comply with the law to begin with, and there won't be any trouble.
Nicholas Hidalgo, Senior Staff Attorney at the ACLU of Northern California, spoke with our own Molly Boygon. You can read Molly's full reporting on license plate readers and the repossession industry at autonews.com. That's Daily Drive for today. I'm Kellen Walker. Thanks to Automotive News executive producer Jake Neer, as well as our own Hans Greimel and Michael Martinez for their reporting for today's podcast. You can get the latest news on Japan's earthquake recovery, Ford's Fathom pickup, and everything happening in the auto industry at autonews.com. Come back tomorrow for a look at Wide Whale's first quarter report on what dealerships did well in terms of customer service and where they came up short.
customers aren't walking into dealerships expecting cheaper cars. They're walking in expecting a really professional experience, and that's where a lot of the friction shows up.
We'd love to hear from you. Let us know what you think of the show and the topics we covered today. Send us an email at dailydrive@autonews.com or leave us a voicemail at 313-444-2774. And if you enjoy the podcast, remember to like, leave a review, and subscribe so you never miss an episode.